You're watching the legal breakdown. So, Glenn, Trump wasn't supposed to have to appear in the courtroom in the Manhattan DA case until, I believe, at the earliest December for the first pretrial hearing. It turns out that he was just ordered by Judge Merchan to appear at a May 23rd hearing. Why is that?
Yeah, Judge Marchand has probably correctly decided that Donald Trump cannot be trusted to abide by the conditions of the protective order Judge Marchand issued last week, telling Donald Trump what he can and can't say, what he can and can't do with the evidence that the prosecutors are giving over in discovery. So, in essence, this is Judge Marchand treating Donald Trump like the dangerous, petulant, untrustworthy person he is. And I really enjoyed the headline from the Associated Press today. Trump to get schooled on rules after district attorneys worry he'll use evidence to slam witnesses. So basically, the judge is going to sit Donald Trump down and he's going to explain line by line exactly what Donald Trump may not do with the evidence that his defense team is about to receive from the prosecutors.
Now, what does he risk if he violates these new restrictions? Because presumably he would still have plausible deniability if he wasn't given this schooling by Judge Merchan. But now that he has, now that Judge Merchan has ordered him to come in by May 23rd for this hearing, he will have already gotten the warning once. So what does he risk here?
Yeah, that's a really important point, Brian, because Judge Merchan is not doing this hoping that it will impact Donald Trump's behavior and all of a sudden he will start abiding by court orders. No, it is to specifically put Donald Trump on notice. So not if he violates the protective order, but when he violates the protective order, Donald Trump can say, oh, I didn't know the precise terms of the protective order. Maybe my attorneys misunderstood them. Maybe my attorneys misinformed me. So Judge Merchan has preemptively taken that defense away from Donald Trump. So when he violates the protective order, it will give Judge Merchan everything he needs to hold him in contempt. So what does contempt mean? Well, it could mean a fine. It could actually mean stepping him back into a prison cell for a period of time. And at its sort of most extreme, it could be jailing Donald Trump pending trial because he has proven that he is unwilling or incapable of following court orders while he's on pretrial release. That would be extreme. I don't expect we'll see it. But, when it comes to Donald Trump's dangerous rhetoric, nothing's off the table.
Well, no, you were a federal prosecutor for 30 years. What do you think is the most likely scenario here with a high-profile defendant, a powerful defendant like Donald Trump, if he is held in contempt?
Yeah, great question. So I dealt with lots of defendants who violated court orders, who violated restrictions that a judge had put on them when they were in pretrial release status. And, the punishment or the sanctions really do run the gamut. Here's what I would expect Judge Merchan to do. For the first violation, it wouldn't shock me if Judge Merchan called him in, read him the Riot Act, and said, look, you were put on specific notice of what you were not allowed to do. You did it anyway. I'm going to give you one warning. You do it again, then there will be a sanction and you will be held in contempt. Then when Donald Trump does it again, the judge might start out with a financial sanction. If he continues to do it, I do think there will come a time when, Donald Trump may find himself inside a jail cell, if only for perhaps a 1 week contempt sanction. But, it really depends on how far Donald Trump wants to push this particular envelope.
Yeah, well, if we've learned anything from the results of the defamation lawsuit, where it took him all of 24 hours before he went right back into defaming E. Jean Carroll again, I think if that gives us any indication, that may very well play out. Glenn, does it hurt Trump's case prematurely if he's already facing these restrictions by Judge Merchan?
It doesn't hurt the case because the jury will never find out about the fact that he violated conditions that were set by the court unless there is some way that it becomes relevant. For example, if Donald Trump violates a condition set by Judge Merchan, and what he does in violating that condition somehow becomes some kind of an admission of guilt in the New York State prosecution, well, then the jury might very well learn about the fact that he made that admission, and we can never put it past Trump to confess to things when he is running his mouth publicly or posting things on his third-rate social media platform. So if he does that and it is admissible evidence, then the jury might not only learn about the admission Donald Trump made, but the fact that he made it after he had been ordered not to. I think it unlikely, but it's not impossible that the jury could come to learn about that, and it could only hurt his cause.
I mean, how wouldn't the jury be able to find out? Because presumably, if we already know, then how could they not know as well?
Yeah, so this is something that gets sorted out in jury selection. So a juror is not disqualified because he or she knows about the case, read about the case, watched news accounts about the case. Most jurors, when it comes to something like this, will know something about Donald Trump and his history, perhaps his history of misconduct. But the question that the judge will ask those kind of jurors who have some pre-existing knowledge is, can you put it out of your mind? Can you promise to completely disregard it and decide the case based only on the evidence you see admitted during the course of the trial? Now, those are some mental gymnastics that can be really tough for jurors to play, right? It's kind of like unringing a bell once you've heard something. But you know what? This is, I'm going to call it the fiction of our jury system. Jurors are presumed to follow the instructions of a judge. And when they are questioned under oath during voir dire, during jury selection, they swear under the penalties of perjury that they're answering these questions truthfully. And Brian, I've had so many jurors say something like, no, I can't put it out of my mind. I know he's a guilty SOB. And that's the kind of juror that we excuse for cause, because they have expressed that they really can't sit fairly and impartially as a juror in that case. So it's a bit of a fiction, but it is the kind of fiction that kind of keeps the criminal justice system up and running.
As a quick aside, and I know we've touched on this before, this idea that, if you're a Trump supporter and you kind of ingratiate yourself into the jury by saying whatever you got to say just to get in there, is it possible, like, just gaming this out, if you are in a jury deliberation and some rabid Trump supporter has snuck through, and maybe they don't have any social media footprint so that, nothing that they said during jury selection could be fact checked. Some rabid Trump supporter comes in and is just immovable and says, regardless of the facts of this case, I am with Trump all the way. I guess what happens in that scenario, and the rest, like, let's say the jury, everybody but that one person is on board with convicting him, and you have this one person who was only there because his or her goal from the very beginning was just to protect Trump. What happens? Like, can the rest of the jury, can they do anything? Is there any, or is that just it? Once they've made it through the jury selection, if they're on the jury, then whatever happens.
Yeah, what a great question. I wish we had a whole hour, because I teach an entire class on this very circumstance, and I contended with this very circumstance several times as a career prosecutor. So here's sort of the general overview of what happens. First of all, yes, everybody works very hard to get truthful, accurate information out of jurors during jury selection. So a mole cannot sneak on the jury with an ulterior motive, wanting to decide the case based on something other than the evidence. It does happen sometimes. And here's how the system handles it when it happens. I was trying a RICO case, and there was a juror who ended up outing himself as basically having lied during jury selection, having an ulterior motive, and he started violating rules that had been set by the court. What happened in that case is the jurors reported it to the judge by way of a written note. We held a hearing, and the judge ordered that juror to be removed during the course of the deliberations. There is a mechanism to have an alternate juror come back, a juror who'd sat through the entire trial, heard all of the evidence. That alternate juror can then replace the offending juror mid-deliberations, and then there's a standard instruction the court gives, and that is, ladies and gentlemen, you are to begin your deliberations anew, as if you never deliberated. So you are now starting from square one with a new jury. Get to work. I've had that happen multiple times, and juries have reached results, including guilty verdicts after that. Here's the danger in that, Brian. If it looks like a judge or the parties are trying to oust a juror for their honestly held beliefs regarding the evidence, What we don't want is a system that can kick out a juror who is holding out for guilty or not guilty, contrary to all of their fellow jurors, because you have to make sure you protect the integrity and the opinions of all 12 jurors, even when they are seriously disagreeing over guilt or innocence. So to answer your question, it happens. It doesn't happen frequently. There's a mechanism to address it, but boy, you better get it right, because if you get it wrong, I can promise you, in the event of conviction, it will go up on appeal and the appellate court will reverse the appeal and send it back down for a new trial.
Got it. Got it. Okay, let's finish off with this. Trump is currently trying to have this case, the Manhattan DA's case, moved from state court to federal court. Why is he doing that? Is it because he doesn't think he's going to get a fair shake with a New York jury?
Oh, I have no doubt he's doing it because he believes he has a better chance of winning an acquittal in federal court than he does in local New York state court. I don't tend to agree with that. But his reason is, you can have a case removed from local court, state court to federal court if there is for a number of reasons, including if there is some sort of uniquely federal thing that has to be litigated by the federal court. For example, if Donald Trump was on trial for committing acts that were within the scope of his official presidential duties, well, then he may have a robust immunity claim that should properly be litigated in federal court. Here's the thing. In this case, paying off playmates and porn stars and falsifying business records in the process because you're trying to steal a presidential election doesn't exactly qualify as within the scope of presidential duties. So in my opinion, he doesn't have any hope that this case will successfully be removed from state court and tried in federal court, but it doesn't surprise me that he's trying.
Okay. Well, we'll leave it there. Obviously, thanks to this new development here, we'll have some news as soon as May 23rd, which is the first time that Trump is going to have to appear before the judge in the Manhattan DA's case. So if you want to stay on top of whatever happens in that pretrial hearing, make sure to subscribe. The links are right here on the screen. I'm Brian Taylor Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.